For these reasons, we agree with the case plurality that conventional concrete reliance interests are not present here. Unable to find reliance in the conventional sense. The controlling opinion in Casey perceived a more intangible form of reliance. It wrote that people had organized intimate relationships and made choices that define their views of themselves and their places in society in reliance on the availability of abortion in the event that contraception should fail, and that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. But this court is ill-equipped to assess generalized assertions about the national psyche. Rehnquist C.J. Casey's notion of reliance thus finds little support in our cases, which instead emphasize very concrete reliance interests, like those that develop in cases involving property and contract rights. When a concrete reliance interest is asserted, courts are equipped to evaluate the claim. But assessing the novel and intangible form of reliance endorsed by the Casey plurality is another matter. That form of reliance depends on an empirical question that is hard for anyone, and in particular, for a court, to assess, namely, the effect of the abortion right on society and in particular on the lives of women. The contending sides in this case make impassioned and conflicting arguments about the effects of the abortion right on the lives of women. The contending sides also make conflicting arguments about the status of the fetus. This court has neither the authority nor the expertise to adjudicate those disputes. And the Casey plurality's speculations and weighing of the relative importance of the fetus and mother represent a departure from the original constitutional proposition that courts do not substitute their social and economic beliefs for the judgment of legislative bodies. Ferguson v. Shrewpaw. 1963. Our decision returns the issue of abortion to those legislative bodies, and it allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. Women are not without electoral or political power. It is noteworthy that the percentage of women who register to vote and cast ballots is consistently higher than the percentage of men who do so. In the last election in November 2020, women, who make up around 51.5% of the population of Mississippi, constituted 55.5% of the voters who cast ballots. Unable to show concrete reliance on Roe and Casey themselves. The Solicitor General suggests that overruling those decisions would threaten the court's precedents holding that the Due Process Clause protects other rights. That is not correct for reasons we have already discussed. As even the Casey plurality recognized. Abortion is a unique act, because it terminates life or potential life. Abortion is inherently different from marital intimacy, marriage, or procreation. And to ensure that our decision is not misunderstood or mischaracterized, we emphasize that our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Having shown that traditional stare decisis factors do not weigh in favor of retaining Roe or Casey, we must address one final argument that featured prominently in the Casey plurality opinion. The argument was cast in different terms, but stated simply. It was essentially as follows. The American people's belief in the rule of law would be shaken if they lost respect for this court as an institution that decides important cases based on principle, not social and political pressures. Casey, there is a special danger that the public will perceive a decision as having been made for unprincipled reasons when the court overrules a controversial watershed decision, such as Roe. A decision overruling Roe would be perceived as having been made under fire and as a surrender to political pressure. And therefore the preservation of public approval of the court weighs heavily in favor of retaining Roe. Casey. This analysis starts out on the right foot but ultimately veers off course. The Casey plurality was certainly right that it is important for the public to perceive that our decisions are based on principle. And we should make every effort to achieve that objective by issuing opinions that carefully show how a proper understanding of the law leads to the results we reach. But we cannot exceed the scope of our authority under the Constitution. And we cannot allow our decisions to be affected by any extraneous influences such as concern about the public's reaction to our work. That is true both when we initially decide a constitutional issue and when we consider whether to overrule a prior decision. As Chief Justice Rehnquist explained, the judicial branch derives its legitimacy, not from following public opinion, but from deciding by its best lights whether legislative enactments of the popular branches of government comport with the Constitution. The doctrine of stare decisis is an adjunct of this duty and should be no more subject to the vagaries of public opinion than is the basic judicial task. Casey Rehnquist, C.J., in suggesting otherwise, the Casey plurality went beyond this court's role in our constitutional system. The Casey plurality called the contending sides of a national controversy to end their national division, and claimed the authority to impose a permanent settlement of the issue of a constitutional abortion right simply by saying that the matter was closed. That unprecedented claim exceeded the power vested in us by the Constitution. As Hamilton famously put it, the Constitution gives the judiciary neither force nor will. Our sole authority is to exercise judgment, which is to say, the authority to judge what the law means and how it should apply to the case at hand. The court has no authority to decree that an erroneous precedent is permanently exempt from evaluation under traditional stare decisis principles. A precedent of this court is subject to the usual principles of stare decisis, under which adherence to precedent is the norm but not an inexorable command. If the rule were otherwise, erroneous decisions like Plessy and Lochner would still be the law. That is not how stare decisis operates. The Casey plurality also misjudged the practical limits of this court's influence. Roe certainly did not succeed in ending division on the issue of abortion. On the contrary, Roe inflamed a national issue that has remained bitterly divisive for the past half-century. Roe may have halted a political process, prolonged divisiveness, and deferred stable settlement of the issue. Speaking in a judicial voice. Article by R.B. Ginsburg, NYU Law Review 1992, and for the past 30 years, Casey has done the same. Neither decision has ended debate over the issue of a constitutional right to obtain an abortion. Indeed, in this case, 26 states expressly ask us to overrule Roe and Casey and to return the issue of abortion to the people and their elected representatives. This court's inability to end debate on the issue should not have been surprising. This court cannot bring about the permanent resolution of a rancorous national controversy simply by dictating a settlement and telling the people to move on. Whatever influence the court may have on public attitudes must stem from the strength of our opinions, not an attempt to exercise raw judicial power. We do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. And even if we could foresee what will happen, we would have no authority to let that knowledge influence our decision. We can only do our job, which is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. We therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. We must now decide what standard will govern if state abortion regulations undergo constitutional challenge and whether the law before us satisfies the appropriate standard. Under our precedents, rational basis review is the appropriate standard for such challenges. As we have explained, procuring an abortion is not a fundamental constitutional right because such a right has no basis in the Constitution's text or in our nation's history. It follows that the states may regulate abortion for legitimate reasons, and when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. That respect for a legislature's judgment applies even when the laws at issue concern matters of great social significance and moral substance. A law regulating abortion, like other health and welfare laws, is entitled to a strong presumption of validity. It must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. These legitimate interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. These legitimate interests justify Mississippi's Gestational Age Act, except in a medical emergency or in the case of a severe fetal abnormality. The statute prohibits abortion if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. The Mississippi legislature's findings recount the stages of human prenatal development and assert the state's interest in protecting the life of the unborn. The legislature also found that abortions performed after 15 weeks typically use the dilation and evacuation procedure. And the legislature found the use of this procedure, for non-therapeutic or elective reasons, to be a barbaric practice, dangerous for the maternal patient, and demeaning to the medical profession. These legitimate interests provide a rational basis for the Gestational Age Act. And it follows that respondents' constitutional challenge must fail. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives. The judgment of the Fifth Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Appendix A. This appendix contains statutes criminalizing abortion at all stages of pregnancy in the states existing in 1868. The statutes appear in chronological order. 1 Missouri, 1825. That every person who shall willfully and maliciously administer or cause to be administered to or taken by any person, any poison, or other noxious, poisonous or destructive substance or liquid, with an intention to harm him or her, thereby to murder, or thereby to cause or procure the miscarriage of any woman then being with child, and shall thereof be duly convicted, shall suffer imprisonment not exceeding 7 years, and be fined not exceeding $3,000. 2 Illinois, 1827. Every person who shall willfully and maliciously administer, or cause to be administered to, or taken by any person, any poison, or other noxious or destructive substance or liquid, with an intention to cause the death of such person, or to procure the miscarriage of any woman, then being with child, and shall thereof be duly convicted, shall be imprisoned for a term not exceeding 3 years, and be fined in a sum not exceeding $1,000. 3 New York, 1828. Every person who shall administer, to any woman pregnant with a quick child, any medicine, drug, or substance whatever, or shall use or employ any instrument or other means, with intent thereby to destroy such child, unless the same shall have been necessary to preserve the life of such mother, or shall have been advised by 2 physicians to be necessary for such purpose, shall, in case the death of such child or of such mother be thereby produced, be deemed guilty of manslaughter in the 2nd degree. Every person who shall willfully administer to any pregnant woman, any medicine, drug, substance, or thing whatever, or shall use or employ any instrument of other means whatever, with intent thereby to procure the miscarriage of any such woman, unless the same shall have been necessary to preserve the life of such woman, or shall have been advised by 2 physicians to be necessary for that purpose, shall, upon conviction, be punished by imprisonment in a county jail not more than 1 year, or by fine not exceeding $500, or by both such fine and imprisonment. For Ohio, 1834. Be it enacted by the General Assembly of State of Ohio, that any physician, or other person, who shall willfully administer to any pregnant woman any medicine, drug, substance, or thing whatever, or shall use any instrument or other means whatever, with intent thereby to procure the miscarriage of any such woman, unless the same shall have been necessary to preserve the life of such woman, or shall have been advised by 2 physicians to be necessary for that purpose, shall, upon conviction, be punished by imprisonment in the county jail not more than 1 year, or by fine not exceeding $500, or by both such fine and imprisonment. That any physician, or other person, who shall administer to any woman pregnant with a quick child, any medicine, drug, or substance whatever, or shall use or employ any instrument, or other means, with intent thereby to destroy such child, unless the same shall have been necessary to preserve the life of such mother, or shall have been advised by 2 physicians to be necessary for such purpose, shall, in case of the death of child or mother in consequence thereof, be deemed guilty of high misdemeanor, and, upon conviction thereof, shall be imprisoned in the penitentiary not more than 7 years, nor less than 1 year. 5 Indiana, 1835. That every person who shall willfully administer to any pregnant woman, any medicine, drug, substance, or thing whatever, or shall use or employ any instrument or other means whatever, with intent thereby to procure the miscarriage of any such woman, unless the same shall have been necessary to preserve the life of such woman, shall upon conviction be punished by imprisonment in the county jail any term of time not exceeding 12 months and be fined any sum not exceeding $500.